Let's take a look at a contracts question. Builder and owner enter into a valid written contract to build a shed for $5,000 according to fully described plans. Builder later calls owner and asks if a lower quality paint is acceptable. Owner agrees. Before builder paints anything, owner calls builder and says, "Please use the high quality paint as stated in the contract." Builder refuses. Which of the following is most correct? Option A says the contract has been modified and builder may use the lower quality paint. In this case, we may examine the written contract and see if the terms have been modified. And in fact, it doesn't seem that the written contract has been modified. It's been more of a verbal modification, which is better addressed by option 2, option 3, or option 4. So option B says owner waived his right to the high quality paint, but owner now has retracted his waiver. That sounds like a good answer. A waiver, verbal waiver, seems like a good theory to pursue in this case. And the fact pattern indicates that the owner has now retracted his waiver. Option C says owner waives his rights to the high quality paint and now cannot retract his waiver. Well, we'll examine in the graphical law diagram that pertains whether owner can retract his waiver. And option D says owner's agreement to the use of lower quality paint is not a valid waiver because owner did not expressly agree to the waiver. This indicates that once owner said go ahead and use the lower quality paint, that neither the builder nor the owner expressly stated that they were talking about a waiver and then that there was express consent to a waiver. That does not show up in the fact pattern, and in fact express agreement to a waiver is not a necessity in contract law in most situations. So let's take a look at the applicable diagram. This, under the objective theory of contracts, which is in common usage, the elements that are necessary is that party 1 make a promise that can be considered legal consideration to party 2, who makes certain promises and provides consideration that is legally recognized. Sometimes the element of bargaining is necessary, and the two parties have a meeting of the minds. That is, they have a mental agreement as to what they are contracting for, and then make some outward manifestation that a contract is present and agreed upon by the two parties, and that their consideration is mutually acceptable to both. In such a case, a bilateral contract is formed, and because all the elements of a contract have been met. Now, what the fact pattern tells us that a contract, a detailed written contract, was present. So all of these elements we can assume have been met with the valid written contract. What the fact pattern indicates is that a waiver to the contract was made. And the notes here indicate that either to make a modification or a waiver, this objective theory of contracts must apply to the waiver or the modification. In other words, in order for a valid waiver to be made, that consideration given by one party must be balanced out or matched by mutual consideration by the second party. In this case, owner allowed a lower quality, verbally consented to a lower quality paint being used, which was a type of consideration or value being given by owner to the builder. However, builder did not reciprocate with his own consideration. Builder, in fact, was getting something for nothing. Builder was getting the opportunity to use a lower quality paint for absolutely no consideration, and for that reason the verbal waiver does not meet the mutuality of consideration characteristic of meeting the objective theory of contracts and forming neither a valid waiver nor a modification on the contract. So for the reasons stated, the best answer here is answer B. Owner waived his right to the high quality paint, but owner has now retracted his waiver, validly retracted his waiver. Let's take a look at what would happen if the fact pattern was changed slightly, and what would happen if the builder went ahead and painted the shed with the lower quality paint, and we say after builder paints the shed, owner calls builder and says, please use the high quality paint as stated in the contract, and builder refuses. What situation would we have now? Well, in this case we may be investigating the theory of promissory estoppel, which is graphically illustrated here. The theory of promissory estoppel, or the reliance rule, occurs when the defendant, in this case owner, makes a presentation, some sort of outward manifestation, in this case consent to a waiver of the use of the high quality paint, makes such a presentation to the plaintiff, in this case builder, and the builder went ahead and used the low quality paint and now is being called to repaint the shed or strip down the shed and use the high quality paint. So for the reasons of having to repaint the shed, the builder has now encountered a detrimental change in his position as far as the use and the cost of the paints, of the two types of paints, has therefore been impoverished by this double painting situation. And before the painting, the plaintiff, the builder, needs to have met this element: justified foreseeable reliance on the presentation made to him by the defendant. So in this case, the defendant, homeowner, made a verbal presentation of a waiver of the use of the high quality paint. The plaintiff, the builder, just foreseeably relied and justifiably relied on that representation of a waiver, and encountered the situation of a double painting of the shed, and so would have incurred impoverishment or detrimental change because of the builder's reliance on the waiver by defendant, the homeowner. And in this case, the theory of promissory estoppel, as an equitable remedy, and could serve as a substitute for consideration, and therefore could solidify the validity of owner's waiver, and have the owner be stopped from retracting his waiver, and could lead to the necessary payment of the extra costs of the builder by owner.